Difference between doctrinal and non-doctrinal legal research. Doctrinal legal research. Doctrinal legal research is often called the traditional or theoretical approach to legal inquiry. It involves analyzing existing legal principles, doctrines, statutes, and case law to develop a clear understanding of black-letter law. Characteristics. Library-based study relying on secondary sources such as statutes, judicial opinions, scholarly articles, and commentaries. Normative focus. Explains what the law is rather than how it operates in society. Precedent-centered. Emphasizes case law and judicial reasoning to maintain consistency within the legal system. Methodology. 1. Identify the research problem or legal question. 2. Collect relevant legal texts, statutes, regulations, judgments. 3. Critically analyze and interpret these sources. 4. Synthesize principles and doctrines into a coherent framework. 5. Draw conclusions or propose doctrinal developments based on legal reasoning. Purpose and benefits. Clarifies and systematizes existing legal rules. Provides predictability and consistency for practitioners and courts. Forms the foundation for legal arguments, academic commentary, and future research. Non-doctrinal legal research. Non-doctrinal legal research, also called empirical or socio-legal research, goes beyond statutes and judgments to study how laws affect real-world behavior and institutions. Characteristics. Field-based, gathers primary data through surveys, interviews, observations, or case studies. Interdisciplinary, integrates methods from sociology, political science, economics, etc. Practical orientation, evaluates the social, economic, or cultural impact of legal rules. Methodology. 1. Define a practical research question, e.g., impact of a new regulation. 2. Design data collection tools, questionnaires, interview guides. 3. Collect and classify primary data. 4. Analyze findings using qualitative or quantitative techniques. 5. Draw policy implications, recommend reforms, or test theories. Purpose and benefits. Reveals gaps between legal theory and lived experience. Informs policymakers about law's effectiveness and societal needs. Suggests evidence-based reforms to improve legal outcomes. Key differences. Aspect doctrinal research, non-doctrinal research. Focus legal texts and doctrines, law in action, social impact. Data sources secondary, statutes, cases, commentaries, primary, surveys, interviews, observations, orientation theoretical, normative empirical, descriptive. Methodology textual analysis, legal reasoning fieldwork, statistical or thematic analysis. Scope narrow, clarifies existing rules broad, examines law's real-world implications. Outcome doctrinal frameworks, interpretative clarity policy recommendations, reform proposals. Explain more about doctrinal legal research. Definition and scope. Doctrinal legal research systematically examines statutes, case law, regulations, and scholarly commentary to articulate and clarify the black-letter rules governing legal relationships. Its scope is confined to legal texts and established principles, focusing exclusively on what the law is, rather than how it operates in society. Output typically takes the form of coherent frameworks, interpretative commentaries, and distilled legal doctrines. Key objectives. Clarify ambiguities in statutory language or judicial reasoning. Systematize scattered precedents into unified legal rules. Predict how courts are likely to decide future disputes. Provide authoritative foundations for legal arguments and academic scholarship. Core methodology. 1. Problem identification. Pinpoint a precise legal question or gap in doctrinal clarity. 2. Source collection. Gather primary materials, legislation, judicial opinions, and secondary authorities, treatises, law review articles. 4. Textual and contextual analysis. Interpret statutory provisions and case reasoning using established canons, literal, purposive, historical. 5. Synthesis of principles. Reconcile conflicting authorities, highlight trends, and propose coherent legal statements. 6. Conclusion and recommendations. Offer doctrinal restatements, draft model rules, or identify areas for legislative amendment. Common analytical techniques. Statutory interpretation using plain meaning, purposive, and teleological approaches. Case law charting to trace the evolution of a doctrine over time. Comparative doctrinal analysis across jurisdictions to identify best practices. Conceptual analysis to clarify definitions, e.g., negligence, consideration. Types of doctrinal research. Type: focus, purpose. Pure doctrinal: existing domestic rules and precedents restate and systematize current law. Comparative: cross-jurisdictional statutes and case law learn from other legal systems. Historical evolution of doctrines over time, understand original intent and development. Analytical conceptual underpinnings of legal terms, refine definitions and theoretical bases. Outputs and applications. Law journal articles and monographs. Case comments and headnotes. Digests and annotated statutes. Legal opinions and bench memoranda. These outputs guide practitioners, inform judges, and serve as teaching materials in law schools. Advantages. Ensures consistency and predictability in legal practice. Provides a clear, authoritative account of current law. Facilitates rigorous argumentation by lawyers and judges. Limitations. Ignores real-world impacts and socio-legal dynamics. May perpetuate existing biases within the legal system. Lacks empirical validation of how law functions in practice. Best practices. Use the most up-to-date editions of case reporters and statute compilations. Cross-verify interpretations against multiple commentaries. Maintain transparency by clearly citing all authorities. Reflect on underlying policy assumptions and potential biases. Doctrinal research remains the bedrock of legal scholarship. Its rigorous parsing of texts and reasoned synthesis of principles ensure that law remains coherent, accessible, and intellectually robust. Conclusion. Doctrinal and non-doctrinal research complement each other. The former sharpens our understanding of legal doctrine, while the latter tests and refines those doctrines against social realities. Combining both approaches yields a richer, more effective legal scholarship and policymaking. Stay tuned for more incredible insights.